listening to Everything Amy. I'm your host, Amy Alonzo. Welcome to today's show. I am so pleased I have three special guests today. I'm going to tell you a little bit about each one. My first guest is the Honorable Susan Maven. The Honorable Susan Maven of New Jersey has been a Superior Court judge since 2001. She has presided over cases in the family and criminal divisions and served in the appellate division. Judge Maven is an ardent proponent of diversity and equity initiatives for the court system. Judge Maven was appointed to the New Jersey Supreme Court Committee on Minority Concerns in 2004. Judge Maven is also the first and only woman to serve as chairman of the State Supreme Court Committee on Minority Concerns in its 35-year-plus history. She served as chair from 2009 to 2014. In January of 2011, Chief Justice Stuart Rabner created a Supreme Court Advisory Committee on Access and Fairness to ensure that the judiciary as an institution embraces access and fairness as an integral part of our core values. Judge Maven served as vice chair of the committee from 2011 to 2014. Judge Maven is presently serving as in her second term as the president and moderator of the National Consortium on Racial and Ethnic Fairness in the Courts. She's also a member of the National Council of Juvenile and Family Court Judges Diversity Committee. Welcome, Judge Maven.
Glad to be here.
I also have with me another distinguished guest, Judge Donovan Foughty. Judge Foughty is a district judge of the Northeast Judicial District in North Dakota. He was admitted to the state bar in 1983. He began his judicial career by election to the county bench in 1987. He was elected to the district bench in 1995, where he continues to serve. He served as a trial judge in tribal courts in North Dakota and as an appellate court judge for the Northern Plains Intertribal Court of Appeals in Aberdeen, South Dakota. Judge Foughty chaired the Tribal State Court Forum in North Dakota, with a final report being submitted to the Chief Justice in December of 1993. He is the past chair of the Standing Committee on Tribal and State Court Affairs. He is the past chair of the Judicial Conduct Commission. He co-chaired the North Dakota Commission to study racial and ethnic bias in the courts by submitting a final report to the Chief Justice in June of 2012. He is also a past chair of the Minority Justice Implementation Committee. He sits on the board of directors of the National Consortium on Racial and Ethnic Fairness in the Courts. Judge Foughty traveled to Norway to study the Norwegian European prison systems. Welcome to the show, Judge Foughty.
Thanks for having me.
And I also have with me another distinguished guest. I have a Judge Veronica Alicea-Galvan. The Honorable Veronica Alicea-Galvan is a 1994 University of Washington School of Law graduate. She took the bench in 2001 as a judge pro tempore and was appointed to a full-time judicial position as an administrative law judge in 2002 before being appointed to King County Superior Court in 2014. While presiding in Des Moines Municipal Court, Judge Alicea-Galvan implemented the only Spanish language court in the state of Washington, enabling hundreds of litigants to address the court directly in Spanish. Judge Alicea-Galvan is an adjunct instructor at Seattle University School of Law and a faculty member for the Washington State Judicial College, where she has taught several courses, most recently Emerging Through Bias Towards a More Fair and Equitable Courtroom course. Welcome, Judge Alicea-Galvan.
It's a pleasure to be here.
So at this time, I would like to start by asking Judge Maven to kindly tell us a little bit about the National Consortium on Racial and Ethnic Fairness in the Courts and what it is that the consortium does.
Thank you. First and foremost, I'm so glad to be here with my colleagues and here to inform your listening audience a little bit about this organization. Our organization was formed in 1989 when judges from 4 states, New Jersey, New York, Washington State, and Michigan, came together to discuss what their committees were doing in each of their states to address issues regarding minority issues and the treatment of minorities within their courts. Once they convened to talk about the things they were doing in each of their states, they believed it would be a good idea to form an umbrella organization to invite other states to bring into the discussion their committees, task force, and commissions, all of whom discuss issues of diversity and equity in their various states, in their various forms. Keeping in mind this is 1989 and 1988, 1989, we were trying to at that time encourage the highest courts of each state, whether it's the Supreme Court or appellate court, to institute commissions in their states if they don't already have them. To do that because at that time there were forms of unrest, inadequate or inequitable treatment within the courts, and we felt it would be appropriate at the time to come together and share best practices so that court systems all over the country can rise up and do a self-examination and make whatever adjustments they felt deemed necessary to do that. So in 1989, there was a meeting convened in Orlando, Florida, and what began as 4 states at that time have now grown over the years to over 2/3 of the states within the country and the territories. So we have over 40 member states who are represented at this time in some shape, form, or fashion within our organization. So the National Consortium is an umbrella organization comprised of the various state committees. We operate by way of a board of directors, and we have 2 other members of our board are with me here today. And we are spanning across the country. So we have judges and representatives from the states in the East, South, Mid-Country, and Far West represented on our commission. And we convene as a board and as an advisory committee on a monthly basis and raise and discuss issues of note, important issues of the day amongst ourselves, and establish policies and resolutions to address and focus attention on issues that we feel need to be addressed in the courts. And we also invite other committees from around the country to join us as members, to share ideas and programs, and we partner with these organizations across the state to support them in their efforts as well.
That's really a great charge that you have. And I was wondering, so are you kind of like overseeing what happens in the courts, or what is your exact involvement on a, case-by-case basis, or is it more, kind of providing information for them?
Well, what our consortium does, we act as a clearinghouse for information. We have a website where we will accept various states have issued annual reports of activities of their various committees. So we assemble on an annual basis for an annual meeting, and we have a report of the states. The states can provide that information posted on our website, on our Facebook page, or Instagram page, so that others around the country can see what's happening in their state and also perhaps access their programs and plans and collaborate on other issues. In addition, amongst the members on our board and on our advisory committee, we have different levels of expertise. We have some judges and lawyers who are on our board who have spent many, many years in the field and have a particular expertise that we lend our expertise to some of the developing committees or committees who are requesting training. Implicit bias is one area that we have a proficiency in. Several of our members are teachers and instructors, and so we're often contacted by states or bar associations, or citizen groups who want more information on implicit bias or other forms of training. And so we lend ourselves and our members to do that as well. And the benefit of having members from across the country is that from wherever people might request assistance, we generally have someone in that area from across the country so that we can be present and assist in whatever service people request of us.
That's fantastic. So right now, if we could now shift over, we were going to talk a little bit about like kind of civics 101. And unless you have anything else that you want to add about the consortium.
Well, we can add more in later.
Okay, great.
We can talk all day about the consortium.
Absolutely. Absolutely. And just as a side note for my listeners, I'm also part of the consortium. I am an advisory committee member of the consortium, and I can tell you that it is an absolutely fantastic organization that wants to help other jurisdictions to be able to address racial inequalities in the court systems. So let's talk about this Civics 101, Judge Maven.
Well, I can just continue as a segue. One of the reasons why we think that this is an excellent opportunity for us to participate on your program is the timing is just right. We've all been very affected and moved by the public involvement, if you will, following the George Floyd, Breonna Taylor, and other unfortunate circumstances following police excessive force, and that led to some of the deaths of some of these people.
Absolutely.
And so we have the groundswell of yet again another set of civil protests, social unrest, movements towards reducing police brutality. And what we find, even as we experience this, it's almost like Groundhog's Day. For those who have been around a long time, we say, here we go again, it's another round of the same brutality, the same public response. It is very important that we continue to march, but many people are asking, why does this keep happening? Why are we in this cycle again? Are there going to be changes? Is there going to be movement? And for some of us who watched another very moving program last night on John Lewis, the great congressman who just passed away, who was the youngster amongst the titans of the civil rights movement, where at age 23, he was the youngest speaker during the March on Washington, standing next to titans like Jesse Jackson, Martin Luther King, and others. Mm-hmm. So as a 23-year-old man, then we look at all the young people who are marching and protesting now, and it makes you want to say to each of them, we love their passion, but you have to understand as well, not only the movement of the day, but understand the history of where we've come from and why these issues are cyclical, why they continue to resound, and just get a sense of history so you know where you're coming from, and so you can take this march a little bit further down the road. Mm-hmm. So that's why I think it's important that those who are in the struggle take a step back, take a moment to learn a little bit of history so you can put things in perspective as you move forward.
Absolutely.
Well, I think it's important to note that although we're in another cycle of a civil rights movement, that this is not a new movement. We've been here before. And although we have many young people who are involved in the struggle, they may not have been here when there were the Rodney Ferguson incident earlier in the 90s, or they certainly may not have been here in the 60s during that civil rights struggle in 68 and 69. And so they may see something happening that they hadn't experienced before. But some of us who have been here over the years, we understand that just about every decade or so, there's an uprising, something happens, there's police brutality or other incidents that cause us to challenge and rise up and want to make civil rights very much important and strengthen the legislation that we have. So I think it's important that we step back and understand a little bit about where we've come from in this country and why civil rights are always going to be an issue for Black and brown people. And so with that, we just want to touch a little bit about those seminal, very important times in our country's history. Mm-hmm. created these tensions that continue even to this day for many of us,
Right.
Black and brown skin.
I think we even go further back than that. If we look at the preamble to the Constitution, we, the people of the United States of America, establish justice. So I want to recognize that even at the founding of this country, there was a principle that was recognized that was justice. But the principles espoused by the written document have not always been the practice of the system that was established.
Yes.
And when you deal with the law, your past decision informs your current decision. It's something we call precedent. So we are constantly impacted by our past. And if we don't understand the historical underpinnings of the individuals who made some of these decisions and the biases that they had, both explicit and implicit,
Right.
the very real prejudices and the very real need to uphold power for a certain group of individuals, if we don't understand those historical underpinnings, the decisions that we make today continue to perpetuate instead of address from a principled perspective what we mean by justice. And I think as Judge Maven discusses some of these seminal times, and later on I will talk about some seminal cases that really help us kind of follow the yellow brick road, if you will, to how we got this way. Because if things such as race are a construct, as we often say, then I propose to you and say that the law is one of the primary architects of that construct. There is not a single agency, there is not a single area of our society, whether it be education or transportation or marriage, that has not been touched in some way, shape, or form by a decision of our courts. And that is the historical analysis that we need to undertake. And if we want to make change, we have to go back to the beginning and start to really look at the foundation of the house that has been built.
And the courts rely on precedent. So one could argue that we are trapped because the courts rely on the past to make decisions in the future. It's very important to look beyond the case itself, but look on the context of how that case came to evolve.
Well, let's look at this United States. Way back before the Revolutionary War, during the Revolutionary War, what we are now called the United States, we were then 13 colonies. We were ruled by England.
Right.
And prior to that, it was ruled by a number of Indian nations. Native Americans were here first, and there was a great genocide after the Europeans came to North America. So
and colonized this the property, the principalities that were here. And then as under European or British rule, English rule, we rose up to fight England because we didn't want to be under their rule anymore. That's why there was the Revolutionary War. We were fighting for our independence. That's the irony of this entire country. We didn't want to be ruled by England, but yet there was the institution of slavery. So even after we became quote unquote free and we had independent, our Declaration of Independence, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. So all men, and therein starts the tale.
Yeah.
Who's really covered by this great Declaration of Independence in 1776. But we have the institution of slavery, where we have in the South, the industry, the bread of life is based upon agriculture, whether it's coffee, rice, sugar, cotton. That's how folks made their money, and they needed people to work.
Right.
In comes slavery. But the North is not innocent, because what got produced as raw materials were shipped north for industry, for manufacturing. So the entire country was supported by and brought about on the backs of Black people brought over here against their will in the form of slavery. And then we have the Emancipation Proclamation in 1865. Abraham Lincoln has to broker a deal to try to resolve what is then the Civil War, the war between the states. It was all an economic war. It was economics. It was based upon economics. It was not necessarily intended necessarily to be the great abolitionist movement to free the slaves. It was what came of it, but it certainly was not the basis of it. It was an economic resolution to a very difficult time in this country.
It's all about the money.
It's all about the money. Moving quickly through, people who are interested can certainly study the history for themselves. You'll hear the term after the Civil War ended, Emancipation Proclamation. We have the Reconstruction period. That's when, now that former slaves are now free, supposedly, now there's the 14th Amendment that gives all men, freed slaves and freemen, whoever you are, equal protection under the law. The 15th Amendment, a couple of years later, gives men the right to vote, whether you are previous slave or not, born or naturalized. So it started back then, and again, we have to read the language carefully, because what they really meant truly is what they meant. It was men. And initially, the rights were for people who held land, landowners. So there were struggles about who really had the right to vote. Out of all of this, when the people in the South realized that they really didn't want Black people to start to have the power to vote, because what ended up happening was Black people were able to vote. They became officers and representatives, and they started acquiring positions of power, title. And so to counter that come Jim Crow laws. Jim Crow laws were laws created in the South to reinstate the power of white privilege over Black and brown people. And so you had special laws for voting. You had to be able to, identification laws, all types of suppression laws to keep Black people in a lower position than white people. So essentially, and I'm sure Judge Galvan I don't know if you can speak about Plessy versus Ferguson. Okay, so there became certain laws that came about to sort of institutionalize the practices at the time, and there were many.
Well, that's really good, because I just, last week's show was about voter suppression, and I did talk about the Jim Crow laws and all of the tactics that were used. So this is great that we get to hear about Plessy versus Ferguson.
So I want to start before Plessy versus Ferguson, because I think it's important to acknowledge that one of the seminal cases that allowed for the treatment of individuals of the African race, or descendants of individuals of the African race, was Dred Scott. Dred Scott versus Sanford, in which a free Negro of the African race was deemed, and I'm quoting the case. So when I use these words, I'm reading from the case, just so that you know, not a citizen within the meaning of the Constitution of the United States. And I want to touch on that too, because the word citizen is so loaded in terms of how we address rights. And I'm gonna ask Judge Foughty about this, because one of the things that people may not realize is that Native Americans did not receive the right to vote to well into the 20th century.
Mm-hmm.
And that they, in their own land, I mean, as I sit here, I stand on the land of the Duwamish. I recognize that. But we have to acknowledge that Native Americans who are literally told that they're not citizens of the very land which was stolen from them. Judge Foughty, do you want to speak to that?
Well, and the legal rationale for that is that they were sort of dependent. They were a dependent people on the nation, and therefore they didn't have the full range of what a franchise citizen would have. And it's you look at it and today and it's absurd, but that's what the law is. I mean, and I'm sure you're going to tell us some more stories like that, but that's the tragedy of it all.
Yeah.
I mean, the law embodies the story of a nation's development. And a lot of times the law is not, it takes care of those who are in power. It doesn't necessarily treat others well.
Mm-hmm.
If it's based upon a fiction to start with, the fiction gets perpetuated.
Well, and I want to point out something. If you look at our Constitution, Article 3, which discusses the judiciary, talks about judges having power in equity. Of all of the legislative, executive, or judicial branch, only the judicial branch is given that task. And yet rarely from a social perspective has that ever been exercised. I'm going back and I'm going to read a little bit about the majority decision in Dred Scott held that, and I'm quoting again here, a Negro whose ancestors were imported into the U.S. and sold as slaves, whether enslaved or free, could not be an American citizen and therefore did not have standing to sue in federal court. So this decision basically said, not only are you not a citizen, but you are even denied justice because of the color of your skin. And that decision really is a foundational decision. It was nullified supposedly by the 13th and 14th Amendments, but if you ever do research, you'll see that it was cited in another case back in our lifetime in the 80s. So these are things that we need to be familiar with. And you also talked about the Voting Rights Act of 1965. We have the Civil Rights Act of 1965, but very few people remember that after the Civil War, there was a series of these acts that were ruled unconstitutional by the Supreme Court of the United States at that time. And there were 5 separate cases that people brought to sue the government because the 14th Amendment had presumably declared them citizens without regard to race, color, or previous condition of slavery. And as citizens, they were supposed to be able to make and enforce contracts, sue and be sued, give evidence in court, inherit, purchase, lease, sell, hold, and convey real and personal property. And yet those civil rights acts were declared unconstitutional as they applied to the states. So states were allowed to implement those Jim Crow laws once those federal laws were overturned. And in the 1883 is when those laws were overturned. And I'm going to quote from a dissent from Justice J.M. Harlan. The statute of 1875, now adjudged to be unconstitutional, is for the benefit of citizens of every race and color. What the nation through Congress has sought to accomplish in reference to that race is what had already been done in every state of the Union for the white race, to secure and protect rights belonging to them as free men and citizens, nothing more. The difficulty has been to compel a recognition of the legal right of the Black race to take that rank of citizens.
Mm-hmm.
And here we are, over 150 years later, and we're still having these discussions. I often wonder what 100 more years of civil rights would look like. So I want us to think about that generational, that century-old impact that decision has had on our justice system. Because when you start unraveling it, when you start picking it apart, and you recognize that this was precedent for so many years and so many generations, you start to see those building blocks. Mm-hmm. So while these things are guaranteed, you have laws that don't allow Black or brown people to buy property in certain areas, to vote, to seek employment, all of these things, to join unions, all of these things are impacted by this decision. Mm-hmm. And it's very important to acknowledge that, which again brings us to Plessy versus Ferguson, right? And this is a situation in which somebody just wanted to ride in a conveyance as anybody else would.
Right.
So this is a case that actually established what we came to know as separate but equal. In other words, now the Civil Rights Act's cases are over. We've deemed that they're not applicable to the states. So now the state's only obligation is you don't have to allow for people to be integrated. That means Black and brown children don't have to go to school together, as long as you have separate but equal facilities and opportunities. Mm-hmm. So the separate was done. The equal never was. And again, that was a case where Justice J.M. Harlan dissented. And in it, he talks about, the white race deems itself to be the dominant race in this country, and so it is in prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the constitutional principles of liberty. But in the view of the Constitution, he acknowledges that no one is above the other. And in terms of the Constitution, that equality must be ultimately what needs to happen. So I'm a very curious person, and I kind of wondered, why does J.M. Harlan dissent in these? Because we would like to think that he's very enlightened.
Right.
He also wrote, he was the primary author of many of the Chinese exclusion cases, and
right.
horrible on Native American issues. And I found in a book that indicated that he, by the way, at the time, he was the only justice who had been a slave owner. So it's curious that he's the one that's dissenting. But I did read in a book that he had a half-brother who had been fathered on a slave, and that I think I like to theorize that in his mind, he couldn't imagine not being able to ride in a carriage or on a train with his own brother, because by all intents and purposes, they had a very close relationship. But it's really funny because, again, while we want to think that he might have been enlightened, we look at some of his other cases and we see that clearly he held very, very strong prejudices. Mm-hmm. But his own life experience perhaps gave him a different lens when dealing with some of these issues. So I've always found that to be fascinating.
Absolutely.
So after Plessy versus Ferguson, which the majority opinion says you can have separate accommodations, it is sanctioning segregation. So what the end of the Civil War meant, and the amendments meant to equalize, the 13th, 14th, and 15th Amendments tried to equalize. Plessy versus Ferguson as a court case now is sanctioning separation and segregation. It's now saying it is lawful to have separate accommodations, separate schools, separate bathrooms, colored only, separate water fountains, separate accommodations. Now we're still in the 1800s, 1898, Plessy versus Ferguson?
Yes, we're still 1888, I think.
88, okay. So what starts to happen next is, okay, so you have these separate accommodations, and now we're into World War I. And there are separate accommodations, there are separate armies, there are separate, battalions. Everything is separated and certainly not equal.
Mm-hmm.
When you get to World War II, and we're fast forwarding through a lot of history, but World War II, it becomes very evident when Black soldiers could not fight with the white soldiers. And they said, we're dying for this country just like everybody else. Why are our barracks like in slop holes? And why aren't we having same accommodations? And so when we think about moving into the 50s, we have people who can't sit, you sit on the bus, but some Blacks have to sit in the back of the bus.
Mm-hmm.
You know, the whole Rosa Parks.
Yeah.
And Rosa Parks wasn't the first one. We know that John Lewis also had a test run, and there were some other civil rights activists, well, people in the struggle, who tested the accommodations in buses and trains. But it's all because Plessy v. Ferguson said you can have separate but equal accommodations. We have a very important school decision, Brown versus Board of Education, which tested separate but equal schools and facilities. And so that's what starts to bring the separation to light as we move into the civil rights era that's a little bit more known to our period of time, a little more contemporary as we move forward. But I don't want to get too far ahead if you have more cases that you want to illustrate.
I do want to illustrate something about Brown versus the Board of Education, because even though we consider that case to be very something that's very progressive at the time, obviously, it's saying, hey, that separate but equal isn't working, and the segregation, and I'm going to read a little bit about this, segregation of white and colored, again, that was the euphemism at the time, colored children in public schools has a detrimental effect upon the colored children. And that line has always stood out to me, because even in getting rid of this idea of segregation as a good thing, it still speaks from the perspective that it is only the colored children who have a detrimental effect. And I would propose that not having those interactions, that shared, that unity, has hurt us as a society to this day. So segregation doesn't just have a detrimental impact on the colored children, as Brown states. It has a detrimental impact on all children.
Yeah.
And I'm going to read on. The impact is greater when it has the sanction of the law. For the policy of separating the races is usually interpreted as denoting the inferiority, again, I'm quoting here, of the Negro group. A sense of inferiority affects the motivation of a child to learn. Certainly things that we can all agree with, but there's learning that was also taken away, I would submit, from non Black or brown children, from white children, because they didn't get an opportunity to learn about their fellow community members, to embrace them, and to see life a little bit through their eyes. And I think that to this day, our society has felt the vestiges of these decisions and the sanction that the law has placed on racism.
That is a really incredible perspective, because we always look at it and say, yes, this was wrong, this is detrimental to children of color, but we don't look at that perspective that it also is detrimental to white children. That's a great perspective.
Well, moving past education, it was also illegal for Blacks and whites to marry. So
yes,
you could not marry a Black person. It was against the law to marry. And certainly, even if a white man deigned to marry a Black woman, if a Black man tried to marry a white woman, it would get him dead, pretty much. Or Emmett Till, accused of whistling at a white woman, and we know what happened to Emmett Till. And instances of that everywhere, all over. Just if a Black man looked at a white woman, So, we know that could bring them almost instantaneous death in a most horrendous way, in a horrific way. So the idea that blacks and whites could not marry continued, and that continued into the 60s. In the very famous case, Lovin was a very important case that sort of finally did away with that notion. And that's into the 1960s. So there are lots of ways that there was separation, forced separation through laws, not just practice, but through law. So again, the notion of separation, Plessy versus Ferguson, it sanctioned separation in so many ways. It affected the very foundation of what we think is our right to love anyone we choose to love. And you couldn't do that even into the 60s lawfully.
Wow.
So where do we come now? So now we're talking about people in the 60s and finally the civil rights movement. There's a recognition that schools need to be equal, accommodations need to be equal, they're not equal, and Black people are starting to stand up for their rights and say we need what was promised to us, equality, under the law, all of us. And that brings us to the major uprisings that are peaceful marches and sometimes not peaceful marches in the 60s. And of course, we've seen the footage, John Lewis, Martin Luther King, but you also had more radical groups also coming up through the 60s as well. And there was a clash between the nonviolent protesters and the folks who wanted more action, more action now.
Right.
And so we get that clash of diplomacy versus activism in various phases along the way. And so we see just a couple of months ago, what is activism, people marching with signs, and then some people may be going a little too far into getting into damage and destruction. That's not a new construct. We've seen that in just about every protest that's occurred from the 60s up until the current time. You have those who are peacefully marching versus others who are perhaps taking advantage of a situation or expressing frustration or anger or other actions that lead to destruction of property, which is not, we don't sanction it, we don't think it's appropriate, but yet it happens, and it has happened repeatedly with every set of protests. And that's why history is important, because it's repeating itself.
Yes.
You need to understand why or how.
Here in Washington State, we're obviously having a reckoning with some of this. Our own Supreme Court came out and acknowledged the complicity of the court system in perpetuating some of these injustices. There's very recently somebody tried to remove a restrictive covenant from one of their deeds. They literally said that you couldn't sell this house to people of certain races. And that was just a few years ago, to try to get the covenant removed from the deed, because those covenants are still on many deeds of many houses. Here in Washington State as well, as progressive as many people may think Washington State is. And I think that we have to acknowledge that a lot of this, the civil rights movement came out of the recognition that, in every single war, from the first, right? The first person killed in the Revolutionary War was somebody of the African race, right? And we, to today, Black and brown people have died for this country, have served this country, and then they come home and they're told that they cannot participate in the very opportunities that they have been fighting for.
Right.
And I think that a lot of that frustration definitely was part, you can get a GI Bill, but you can't buy in this neighborhood. And they can restrict you from buying in this neighborhood. I mean, those are things that were upheld well into the 60s and 70s. Again, we can follow the bouncing ball. You remember those little songs that they used to follow the bouncing ball.
Yeah.
In terms of any of these cases, you can follow the bouncing ball and see how each case is a building block upon the next. I mean, we are a country that allowed for the incarceration of its own citizens based on the fact that they had Japanese ancestry. And the Supreme Court approved that executive order in the Korematsu decision. Initially in Hirabayashi, they approved and said that the curfew was allowed for people of Japanese descent. And then they allowed them to be removed from their homes, to lose their property, and to be placed in, for all intents and purposes, concentration camps here in the United States. We can call them whatever you want to make it sound nicer, but that's what they were. And we have to, if we don't acknowledge that, we lose a sense of perspective and reality, and we can't come to terms or reconcile that we may have been wrong. And reconciliation is necessary in my perspective.
Absolutely. And these Asian Americans, they were all people that were born here, correct?
Correct.
So they were true blue citizens of the United States of America.
Absolutely.
And they were still mistreated by the United States government.
Correct. I don't know how many people of German descent they put in these camps.
I don't think they had any American Germans placed in it.
I'm being facetious, obviously.
I know you are. I know you are. I'm being facetious too.
But I just want to note
Right.
that we're taking a very a biological marker of skin color and pigmentation to make these extraordinary decisions and the dehumanization that involves that. We've done it to Native people. We still are, obviously, in many ways.
I think an interesting discussion about racism, just by looking at Supreme Court cases, district court cases. I mean, we have a whole history of racism within our system, our legal system. And, to study that really gives somebody a perspective about what this country is about. And I love this country. I love the people in this country. It's a great country. But I think we need to be critical about our history.
Absolutely.
And I'm very appreciative, particularly recently, how people have been coming out and talking about what has happened in the past, because there's a lot to be critical about. I mean, the United States never kept a treaty with a Native American tribe.
Yeah.
To be a Native American, the law can be extraordinarily complicated. So if you're in an Indian nation, as some people call them Indian reservations, but if you're on an Indian nation, and let's just talk about criminal jurisdiction. So if you're an Indian on an Indian nation that commits a crime against an Indian, that person committing the crime could either be charged in federal court or in tribal court. And depending on what particular Indian nation it is, and that it could be a public 280 reservation where the state might have concurrent jurisdiction, then somebody could be tried in state court and somebody could be tried in a tribal court. So theoretically, a Native American could be tried in 3 courts. In North Dakota, in my jurisdiction, the state doesn't have jurisdiction over most of the Indian nations except for Spirit Lake. There's a unique statute where the state has concurrent jurisdiction. So if you're a Native, so in Indian country, and they say the Indian nations are sovereign, well, they're sovereign to an extent. A tribal court doesn't have jurisdiction over a non-Indian. So what happens is if a non-Indian commits a crime against a non-Indian in Indian country, that comes to state court. If a Indian commits a crime against another Native American, then that individual could go to tribal court or federal court in North Dakota.
Okay.
Depending on the crime. And the Indian nations have very limited jurisdiction. So as far as punishment and things of that nature, they're like they would be what we would call misdemeanor crimes. They have jurisdiction over misdemeanor crimes, and then the federal government would have jurisdiction over the more serious felony crimes. But if you're a non-Indian and commit a crime against an Indian, that Indian nation would have no jurisdiction over you, which, you know, is sad. They should have jurisdiction over, if somebody commits a crime against somebody in your territory, you should have jurisdiction, but they don't. And in our state, the exclusive jurisdiction would fall with the federal government. So in domestic violence cases, that becomes a real problematic area because the federal government doesn't like dealing with misdemeanor crimes. So you have crimes like menacing or other crimes of that nature, or terrorizing or something like that, where if it's a crime against a Native American by a non-Indian, then the feds have got exclusive jurisdiction. And that can be real problematic. And the law becomes more complicated when you're a Native American, just as a matter of fact, in a criminal context.
Is there any nexus, or what is the impact of some of the civil rights issues or concerns that we're seeing? Are any of those issues present in Indian country?
Well, one could argue that maybe some states are trying to disenfranchise Native Americans from voting.
Mm-hmm.
I mean, that's been an issue. Personally, I think the criticism of the U.S. Supreme Court in the next couple decades, the criticism will be as it relates to or as it relates to voting rights.
Voting rights.
I think that's what history is going to show. I may be wrong, but unfortunately, I'm concerned about people being disenfranchised.
Mm-hmm. One of the things that I find interesting, one of the cases that involves a tribal court is Dollar General versus Mississippi Choctaw Nation. And the reason that this is an important case is because in this case, Dollar General had signed a lease with the tribe agreeing to tribal court jurisdiction over claims arising from the lease. A 13-year-old boy who was a tribal member was assaulted by the manager of the store. He was non-tribal, and after the U.S. Attorney's Office failed to pursue criminal charges, the family sued the manager and Dollar General in tribal court. Mm-hmm. Dollar General was arguing that the tribal court was not a neutral forum, and that a neutral forum is not available to non-Indians. And I want to kind of parse out that idea, because for generations and to this day, we assume that our courts are, quote, neutral. Mm-hmm. And we have assumed it even in the face of so many decisions that show and have established prejudice and racism and have supported that. And in many cases, given us the language that we use to this day. Justice Sotomayor famously asked, "You assume that judges are not neutral." In other words, we are to accept that judges in our quote unquote state courts and regular courts are somehow more neutral, as that term is used, than tribal court judges. And even within that context, you see racism rear its ugly head, because that's what that's about. That this company does not feel that they can get a fair shake in a tribal court, and yet day in and day out, brown and black people are asked to go to court and presume neutrality and to lend legitimacy in light of that history.
Some years ago, I had a personal injury case on the Spirit Lake Nation, and I was sitting as a tribal judge. And the defendant in the action was a power company. And what had happened was a teenager, had climbed up on some transformers and got electrocuted, and essentially the nature of his injury related to his eye and the retina, and he was blinded or partially blinded. So they sued the Otter Tail Power Company, And the jury, of course, was members of the Spirit Lake Nation. And they found in favor of Otter Tail Power Company because they felt that they weren't negligent. There was no negligence on their part. The kid was climbing on top of electrical transformers, which, you know, anybody knows you could get electrocuted if you climb on top of electrical transformers.
Right.
And they found in favor of the power company. So
The interesting thing about Dollar General is the reason that Dollar General lost is because it was a split court 4-4, because it happened when Justice Scalia passed. And so when it's a split decision like that, an even decision, you go back to the underlying decision of the Fifth Circuit in this case.
Ooh. Wow.
Well, I can say, I just want to circle back around to the National Consortium for a moment. So what we've heard when we spoke about the Japanese internment situation, of course, after World War II, we can say that we have our annual conferences at various cities around the country, at least when we could have our annual conferences. And several years ago, we went to Cody, Wyoming, which is near Powell, which is somewhere near Jackson Hole. It's in Wyoming. And many people don't have an occasion to go to Wyoming, but we did. And we visited Heart Mountain. Heart Mountain is one of the 10 Japanese confinement sites that were created around the country after World War II. And Heart Mountain has a foundation that supports and continues to support Japanese Americans who are now generations from the 1940s, but still feel the vestiges of that, I'll dare say, incarceration, because those persons were rounded up on that particular property. I believe they made provisions for up to 10,000 people who could have been housed, if you will, on Heart Mountain in Cody, Wyoming, which was a remote, small little area that was carved out by the U.S. Corps of Engineers to create this facility, if you will. But there are other locations around the country that also confine Japanese American. But my point is, as an organization, we deliberately went to Cody, Wyoming, and learned about Heart Mountain and learned about the internment of Japanese people at that time, because it was important to support that community. Two of our board members or advisory committee members are of Japanese American descent, and that was a very important trip for us. Mm-hmm. Thereafter, we took another annual conference was in Ferguson, Missouri. And again, learning history. Several years ago, there was a young Black boy, Michael Brown, was killed by a police officer in Ferguson, Missouri. It caused the same kind of unrest that we're seeing now, police brutality, accusing the police of shooting an unarmed young Black man. Out of that, the police officer wasn't charged because the evidence showed that perhaps the young man might have been complicit in something. But the point is, out of that upheaval came the uprising and the issues regarding inappropriate fines and fees that Black, brown, minority people are disproportionately detained or jailed for failure to pay fines or fees. So they're being incarcerated for being poor.
Yeah.
Finding that certain fines and fees were ways that municipalities funded their municipal budgets on the backs of people who could not afford to pay. And so there have been revisions in certain areas in the area of fines and fees. But the point being that we had our conference in St. Louis, and while in St. Louis, we did a town hall meeting in Ferguson, Missouri, to meet with the community, the new leaders, the new chief of police, to find out what happened now, what's happening in Ferguson. Has it really changed? Mm-hmm. After all the uprising, has there been a change? And it was very important that we did that. A few years ago, we were in Minneapolis, Minnesota. We had our conference there, and that was soon after Philando Castile was killed. Philander, he was shot in a car. He was riding with his girlfriend who was driving. Police officers stopped him. When he went to reach for his ID out of the glove compartment, they shot right into the car, killed him right in front of his girlfriend who was driving and his little girl who was in the back seat. And so we went to a special art exhibit honoring him and his life, but again, in support of the people there who suffered a tragedy, police shooting then. And now, of course, George Floyd is killed there now. So perhaps we can understand why Minneapolis is so upset, because they just went through the death of Philander a few years ago. But we visit these sites intentionally and with intention to be able to learn more about what's happening in that community, to support the community's efforts for reform, whether it's police reform, civil rights, justice, judiciary reform. And that is another part of what we do as a consortium when we move our business around the country, to ensure that we touch base with the communities there and let them know that there are voices that support their issues and hear their concerns. And it's just important, as we brought up the issue of Japanese internment, I wanted to share that that's part of our experience as well. So,
and Judge Maven, is anyone able to attend the National Consortium conferences?
Our conferences are typically attended by individuals and representatives of their organizations. Our website is national-consortium.org, and our information is posted at or around time of registration. We start posting information. But we have information on our websites now on some of the states and their state actions, information where we've been on our other conferences, resolutions that we've passed recently. So it's a resource for training and other information that might be shared amongst our organizations. And it's an open public site, so you don't need to have a special log on to access our information.
Fantastic. Thank you so much for providing us with all the details on how to reach the consortium. And we have come to the end of this particular episode, and I want to thank all of you for joining me. And I want to also extend an invitation to come back, because these are very important issues, and I know that there's so much more that we can say about them. So I'm hoping that you'll come back for a second episode of everything Amy.
Thank you, Amy.
Thank you very much. It's been a pleasure.
Glad to be here.
Thank you so much. So, ladies and gentlemen, thank you for joining us. That was the Honorable Susan Maven, the Honorable Veronica Alicea-Galvan, and the Honorable Donovan Foughty, who joined me today.